Good morning. Welcome and thank you for joining us for this morning's live panel discussion, which forms part of the Data Centres Ireland Virtual Festival. My name is Hugh Robinson. I'm the Exhibition Director for Data Centres Ireland, which cannot be physically held this year due to the pandemic, but will take place next year on the 16th and 17th of November 2021 in the RDS in Dublin. Data Centres Ireland Virtual Festival consists of live panel discussions, 2 per day over the course of this week, featuring industry leaders and experts discussing key areas affecting data centres, both in Ireland and internationally. As well as a range of live discussions, the festival also has a range of on-demand content which can be accessed through the Data Centres Ireland website. This morning's webinar discusses the issues related to Brexit. Where are we? The likely impact on Ireland and what this may mean for the data centre sectors. To try and bring some clarity on this unenviable subject is a quite unique and exceptional panel of experts. If you would like to ask any questions, please put these in the chat box and they shall be addressed at the end of the discussion. This webinar will be recorded and uploaded onto the Data Centres Ireland website as additional on-demand content. The moderator for this morning's panel discussion is Simon McAllister, partner and Brexit lead of EY Ireland. So without further ado, I shall hand you over to Simon. Simon.
Thanks, Hugh, and good morning, everybody, and you're very welcome to this morning's session of the Data Centres Ireland Virtual Festival. Special thank you to everyone who's joining who has a good memory, who can remember what a real festival feels like, and hopefully we'll get back to some of those in due course. This morning's session is going to talk about Brexit, and our panelists this morning have a variety of perspectives on both Brexit and then the specifics of how it will apply to data legislation, and the data centre sector in Ireland. As Hugh said, I am a partner in EY. I have a day job, which is in strategy and transactions, and I have also acquired the role of Brexit lead. I'm still trying to work out what I did to deserve it, but I am doing it. I was talking to someone on Monday who did ask me, was I looking forward to 31st of December and the end of that role? And after I stopped laughing, I explained why I thought that role would continue for at least another year beyond that. Just to introduce our panel, Vincent Power is a partner with A&L Goodbody. He is a specialist in the EU competition and procurement team there, specialising in EU law, competition issues, antitrust, merger control, mergers, working with both public and private sector clients. He has won a long list of awards in the legal space for work on specific projects and his expertise in the area of competition law and antitrust in particular. Una Fitzpatrick is the Director of Technology with IBEC Ireland. She's a graduate of Smurfit Business School and has spent over 15 years working in the digital and knowledge economy, and the last 6 with Technology Ireland. Technology Ireland is an association within IBEC, which, for those of you who don't know, it's a very prominent voice in Ireland, representing the business community and representing several sectors and groupings within that. She's an executive board member of Digital Europe and sits on the board of FIT Limited, Fast Track into Technology. Marie McGinley is a partner with Evershed Sutherland law firm. She is the head of their intellectual property, technology and data protection team there, and does an awful lot of work with data centres in Ireland. She works in both contentious or dispute matters and commercial matters relating to outsourcing, technology, data protection for both domestic and international clients. She's a recognised expert here for data protection law, an area that continues to be very, very high profile for their clients, and indeed we see that with ours as well. So, very quick sort of intro to where we are at the moment, and I'll start the conversation with Vincent around the negotiations. But it's hard to believe, and I joked with Hugh about this many months ago about the fact that we were scheduling a session for November to talk about Brexit when we thought it would all be finished and it would all be done and dusted. We have blasted past various deadlines. We had the UK imposed deadline of mid-October, which everybody kind of ignored. We had an EU deadline a few weeks later, which again sort of slipped past. And now we are at the mid-November deadline that the EU have said, and depending on how you define mid, we're either past it or rapidly approaching it. The reality is we are probably in a key crunch phase of probably the next fortnight. The EU and the UK do need time to review the deal. Parliamentary processes will need to be followed, legislation enacted. We would hope that they will be inventive around maybe stretching that or accelerating it, or finding some period in the first month or two of the year. We can talk about some of those mechanisms. But it still is the three key issues which you'd have heard of fisheries, level playing field or state aid, and then the governance mechanisms that go around enforcing all of that. It's been interesting to see how some of the areas of equivalence decisions, which we can explain exactly what they mean, relating to both financial services and data, and its most general sense in terms of data and data transmission, have resurfaced as issues in the last few weeks. And Vincent, maybe just starting with you, is that something that you're surprised to see? As some people would have said they were relatively settled, there was going to be temporary equivalence decisions granted, and both data and financial services would be very wrenching, not just to the UK, but to the EU as well. Are they just negotiating tactics?
My goodness, Simon. First of all, thank you very much to the organisers for inviting me to Simon. Simon, you're starting with the easy questions, aren't you? The first thing I suppose would be is it's actually probably worth maybe for a moment. It's not a surprise that those issues are coming up at all, and I think it's actually probably worth stepping back for a minute, because like the person who said to you, you're looking forward to the 31st of December. There's a lot of people who are actually seeing this as, oh, if we can just get to the 31st of December and get a deal, we're all done and we're home and dry. I'm going to ruin everybody's day. There will be Brexit negotiations and Brexit deals for as long as the European Union and the United Kingdom exist. There will be dozens and dozens of negotiations and agreements for as long as that takes. It's not about the next 43 days. And we're doing this in a very sort of typical way that the European Union and the EU operates. Deadlines are aspirational. They are poetry. They're not mathematics. If you think about something like the merger control regulation, where companies merge, that was proposed in 1972. It was adopted in 1989. So these negotiations, and Sky News and CNN land, this is all instantaneous, and when we get there, and overnight the FT has said, oh, optimism that there could be an agreement and so on. So it's not about the next 43 days. It's a very dangerous way to negotiate. If you think about something like GDPR, GDPR was only 99 articles. It was a huge problem for the data sector, but you had 2 years and 1 month to implement it. If you think about it, if we get a deal somewhere in the next 43 days, we may have a few days between the time it's adopted and the time it could come into force, unless there's a prolongation or an expansion. And even if you think about the withdrawal agreement that we've had, there are already corrections to that. There have already had to be amendments published to that. So if you pick up the withdrawal agreement and read it start to finish, you now have to read the errata as well. So I think you'll find that sort of issues like data convergence and financial services, they're the very issues that are going to have to be looked at. The problem is that so much attention in the Brexit negotiation has been on goods, but not services. And this is sort of, we're fighting not last year's battle, but, last century's economy. Now, goods are extremely important, they've got to be dealt with, but actually there's issues like data, the new oil, that's what should be focused on. There are 11 strands to the negotiations, and there will be further agreements. So just like you've had with Switzerland, where there was an agreement started in the free trade agreement in 1972, we now have over 100 agreements with Switzerland, and the same thing will arise. So you'll find that convergence issues, recognition issues, that's all extremely important. And just to put it into maybe just two final thoughts, Simon, maybe just to put it into context, the reason why we're going to need those sort of arrangements are, the United Kingdom has been part of the European Union for essentially 50 years. People like Emmanuel Macron Leo Varadkar and so on, they weren't even born when the UK joined the European Union. So you have all those rules. You've had 50 years of convergence, and you will now have a certain amount of divergence. It won't be so bad at the beginning. It's very much like when Ireland became independent from the United Kingdom in 1922. The first few weeks, I remember them well, the first few weeks weren't a problem because we just simply followed the same rules. But actually, here, some of those rules will no longer apply. And that's the sort of issue that, Una and others will speak about, and Marie will speak about very expertly, that whole divergence that's going to occur. So that's the first point, that we are taking out all the wires out of the system after 50 years, and we're now agreeing to put some of them back in one by way of an agreement. So if you're young and you want a career, when you grow up, you want to be a Brexit negotiator, you will not have a job for a year, as you think, Simon. You'll have it forever, I'm afraid. And the second point to think about is just the relative negotiating points. The United Kingdom is a huge economy, fifth or sixth biggest in the world, about 3 trillion. But if you think about the European Union economy, it's about 18 trillion. And those are large numbers and difficult to comprehend. But just keep this image in your mind. The European Union economy is, in diameter terms, a basketball. The UK economy is a table tennis ball. Now, what's really important is the movement of data. The Schrems case, all about movement of data to the United States. If there isn't a deal, then the UK becomes the United States in one way, a third country. And that's why it's extremely important. That's why it really matters. And that's why, if you were starting here, it's 1,609 days since the referendum. If you were starting now, I wouldn't let this to 43 days. That's why there may be some form of extension, but if there isn't, there ought to be. So hope that helps, Simon.
Yeah. So, I mean, maybe what we'll do for those watching, we'll move sort of from general into a bit more specific, and then we'll get to data center. Una, maybe if I could just ask you to pick up Vincent's point about services. And, he's absolutely right. There has been this unhealthy focus on, for the UK economy, services is 80% of their economy, and they've largely been ignored. Data centers obviously have customers. Customers are largely those technology businesses who are services businesses. What sort of issues are you seeing, with companies, or that you expect to see, that will impact that services sector because of the absence of specific provisions for them?
Absolutely. I mean, it's something that, from a lobbying perspective, we've been raising, kind of since Brexit kind of was kind of proposed, even before the actual referendum itself, of the difficulties that this would present. And I suppose even, from a negotiation point of view and a lobbying point of view, we would have been highlighting the issues for the sector. But I suppose, to Vincent's point, the goods thing was really what people, I think, the tangible was much easier to envisage and try and solve, even though it hasn't been solved yet. And I suppose it was kind of, once we get that done, we'll sort out the rest. And now there is the question as to whether, as part of the goods negotiating, were they holding back on the agreement around kind of data and services, because that would either be the carrot or the stick, depending on what needed to be enforced. So that was our perception, in terms of, obviously, we were constantly raising these at a European, through Digital Europe level, with the Irish government through Technology Ireland and IBEC. And I suppose there was a bit of a reticence to kind of get too far into the detail on those issues until the goods issues were sorted. But I think we are kind of seeing the kind of fruition of that now, because obviously we still haven't really sorted the goods issue. We've got 43 days left, and we haven't sorted the services and data issue either. So it's kind of a whole kind of collection of issues, and I would be hopeful there would be some sort of an extension, or even an agreement that, as part of a skeleton deal, that in the next 6 to 12 months we're going to deal with X, Y, and Z, and maybe set out a time frame that's a bit more realistic and achievable. But in terms of how it'll impact on members and kind of what companies are doing to prepare, because obviously business likes certainty, and they need to kind of be able to plan ahead. And I suppose what we've seen especially is kind of dual location. So people really focusing on kind of having a presence in both jurisdictions. So it's kind of that kind of, no matter what they do, the politicians or the you know, whoever, we as a business can get through this. And I think that has been the way that a lot of people have kind of said, you know, we're just going to have to play our own course here, because we can't rely on anyone else to come up with some magic solution. And kind of that kind of you know, they're kind of companies looking at it for themselves. You know, obviously we've seen companies either pull fully out of various markets, be that from the UK, pull out of Ireland, or Ireland pull out of the UK. You know, that's more of a rare, you know, example, but definitely we've seen kind of creative kind of ideas from across industry on how they're actually going to deal with this. And, you know, even splitting some, you know, company structures to form entirely new entities, new names, but still being part of a more global structure. So it's been really interesting to kind of see that with companies, and, you know, even the relocation of people, and, you know, making sure that, you know, even from a HR basis, which I you know, some of my colleagues have been supporting companies in terms of relocating people, making sure that they can get set up and everything from an Irish perspective. So it's been, you know, it's been a huge effort by the business community, because they have recognized that they can't rely on deals or agreements, that they just have to go ahead and do this themselves. So I suppose, you know, in terms of those who are most impacted and those who actually, you know, will make this work for, you know, people and life and keep everything going as we expect, that's really what the business community has been doing.
Yeah, and obviously some of those practical things about relocations and others greatly complicated by COVID and quarantines.
Absolutely,
and
yeah,
and everything else. So
yeah, it helps put Brexit in perspective when you have a global pandemic to deal with as well.
Indeed. Marie, maybe just to bring you in on some of the, maybe just bring us through some of the key issues around data that arises from Brexit, whether that's regulatory, operational, or legislative, maybe.
Yeah, I suppose maybe just to start off by saying this has been probably the last 2 weeks have been quite a significant 2 weeks in the data protection world, with the much anticipated European data protection guidance on supplemental measures and essential guarantees for transfers to third countries, which I think is very relevant, obviously, in light of today's discussion. And then the new draft standard contractual clauses that have been issued by the European Commission. So I think from a European perspective, there seems to be an urgency with regards to transfers to third countries coming to play. And obviously these documents have been issued for consultation with a very short consultation period, both one for the end of November and the other for the 10th of December. So I think that kind of sends a resounding message in relation to transfers to third countries generally. But maybe just to kind of take a step back and looking at it from a purely regulatory perspective. So kind of GDPR in itself prohibits the transfer of personal data to third countries unless that third country can provide an adequate level of protection. Now, the legislation does provide for certain exceptions, but not exceptions in terms of, let's say, an exemption as such, but exceptions in terms of standards that are deemed to be equivalent or essentially equivalent to the standards provided in the EU. So for organisations that are, let's say, facing a Brexit plan, a lot of organisations are, I think, looking at this very closely now. And I think as the days and the weeks pass, it's becoming a matter of urgency, I think. And one of the things Una pointed to, and it's what we're seeing in practice, is there are a lot of organisations actually splitting their companies and essentially having a dual presence. And I think from a practical perspective, I think for organisations, this is going to have bigger ramifications than I think they realise. Because if you take a step back and you look at what the UK have, let's say, considered from a data protection law perspective. So the UK have stated that the GDPR will remain in being, but it'll be the UK GDPR. So they will essentially introduce the UK GDPR post-Brexit. That's what's anticipated. And that will sit alongside the UK Data Protection Act 2018. So that will sit side by side with the EU GDPR and, let's say, then the relevant national legislation that's in each of the relevant jurisdictions. One important point I think that's important to bear in mind in relation to those two elements is the UK GDPR is anticipated to have extraterritorial effect, like the current GDPR does have in place. So for those organisations that are providing goods and services to individuals in the UK and monitoring individuals in the UK, from that perspective, they will be subject to the UK GDPR. Now, that's all well and good, provided the UK GDPR and the GDPR remain the same or essentially the same. As, let's say, time evolves, and given obviously that the UK will have freedom to reassess their framework going forward, from that perspective, I think that's where, let's say, companies may come into difficulty. In reality, and thinking it through, will we see them move significantly from the GDPR? I can't see them doing that, to be honest. Many companies have spent way too much time and money investing in becoming GDPR compliant. I think it would be remiss of the UK at this stage to start to move away from the obligations that are set out in the UK GDPR, which will be equivalent to the GDPR. So from that perspective, hopefully they will remain as united or as similar for as long as possible for organizations. Then also maybe kind of looking at it from a regulatory perspective, that the Information Commissioner in the UK has actually come out as late as the 16th of October to say that from the 1st of January, it does anticipate that organizations in the UK will require standard contractual clauses to legally receive data from EU companies going forward. So that kind of sends a strong message in itself, while it does also state that an adequacy decision or an adequacy assessment is ongoing, which, to be honest, and I think if we're all honest with ourselves, that would be the preferred approach. So that we could in effect have free movement of data between the EU and the UK going forward. I think that's what their preferred approach is. I would say that as part of the assessment that's currently being undertaken, there is an obligation on the EU to assess the security and surveillance legislation that's put in place. And as I mentioned, the European Commission recently, as last week, issued guidance in relation to supplementary security measures, but also accompanied that with a second document that talks about essential guarantees. And as part of that essential guarantee, it references the fact that, in effect, these obligations require an assessment of surveillance legislation. So the UK has, and in reality, come under criticism as a result of their surveillance legislation. And if we look to Schrems 2, it's not unlike the surveillance legislation that resulted in Schrems 2. So it will be interesting to see what position the European Commission takes in with regards to its assessment of the UK's surveillance legislation in that regard. I would say in reality that an adequacy decision is not a slam dunk. While they will have a UK GDPR and equivalent kind of legislation, we can't kind of forget the surveillance piece. And bearing in mind the guidance that has been issued this week, it's clear that this is front and centre for the European Commission. So it'll be interesting to see what transpires.
Yeah, and maybe Vincent, if I come back to you on just link to that point about the surveillance piece, and if we think about how data, is so integral now to policing and to, the judicial matters that the EU has placed very high up in terms of priorities, and the ongoing cooperation with the UK, which doesn't seem to be a foregone conclusion in terms of how they're approaching it. How does that affect whether and how we would reach an agreement? And then maybe a sort of a sub part of that, if there is no agreement, like what does happen then?
Again, Simon, very good questions, very hard questions. And just before I mention those, I think just to echo Marie's point, what's really interesting is, two messages I would say to businesses. One, make sure that you lobby the United Kingdom to make sure that when they adopt the GDPR, that they really do keep the same as the GDPR, because every little scintilla of difference costs money to business in terms of compliance. Because the more convergence you have, if you're running a data center, if you're in the data sector, the more convergence you have, you only have to navigate by the North Pole. But as soon as you get a magnetic North Pole of the UK, you've got extra convergence costs. And, it's a little bit like there are 19 countries in the euro. In the EMU that operate the euro. There are a number of countries outside which also operate the euro, such as the Vatican State. They're not in the Economic and Monetary Union, and they operate it as well. And that would be the UK in GDPR terms. So if you think about Schrems 2, for example, the July ruling of the court, that came about because there was a reference from an Irish court to the European Court and the preliminary reference regime. That possibility will not be open to the UK. Those preliminary references are no longer possible from the UK post the end of the transition period. So what will happen will be is that the UK will be a rule taker rather than a rule maker or co-maker or rule participant. So that's really important in that context. So then going back to your question, if there is no agreement, then the United Kingdom is a pure third country, and that's where we have no rules to abide by. And that's where, every convergence, every recognition decision matters. And that's where it's going to be really tricky and difficult. And as data is the new oil, that means, it's really important in that context. And again, Una and her colleagues, what businesses need to do really is to lobby all the governments to say, look, don't worry about face and face saving here. Let's say the end of the transition period happens, but we can have, and paper doesn't resist ink. Paper won't resist a provision which says the GDPR or that arrangement will continue on, for 1 year or 2 years or whatever, till a new agreement or a new arrangement is put in place. Because it's a little bit like the London Underground. We want to mind the gap here. We want to mind the gap. If the data falls into that gap, that's the problem. And if you think about like, people think that the United Kingdom will finally leave at midnight. No, this is all determined by Brussels. It's midnight Brussels time. It's the 2300 hours on the night of the 31st of December. And if there is that gap and we have no rule book, then that's where the issue arises. And if you think about the difficulties, like if you think about GDPR, people had, as I say, 2 years and a month to implement those 99 articles. And yet when you looked up, US newspaper websites like the LA Times, 3, 4, 5 months on, they still hadn't actually absorbed the issue and dealt with it. So there'll either be data passing illegally and difficult in a very difficult way, or we're going to have to actually, legislate for it, and it's far safer to legislate for it. So the short answer to the question, if there are no rules, then it can be chaotic. But could there be rules? Yes. And then post this regime, I think it's really important that the European Union and the UK adopt the same regime, because it's better for business, it's better for data subjects. Now, it's going to be difficult, and I'll close on this point, Simon, that it's going to be difficult. You've got to remember why the European Union is so fixated by data protection. It's good for citizens. And if you think about it this way, the European Union, and there's a very good book published recently. It's not by me, and I have no interest in this book whatsoever. But it's called The Brussels Effect, and there's a very good chapter in it about data and how the European. It's written by an American an academic in the States called Bradford, Anu Bradford. But if you think about it, the European Union is protecting citizens and protecting their data rights. Therefore, it's going to go to great lengths to do so. And it's going to want to be seen to protect rights, because Brexit, one of the lessons of Brexit is you got to protect citizens, and citizens got to understand why they're in the European Union to stay in the European Union. And if you're seen to uphold their protections and their right to privacy, that will work. So again, if businesses are lobbying, it's all about protecting the citizen and the consumer, if you will, and that's really important. And that's why it's going to be important in that way. And I'll leave you finally with this thought. If you're very tired of life and you do end up reading the withdrawal agreement, one of the very first provisions, about Article 8 or so of the withdrawal agreement, is an obligation that the European Union imposes on the UK not to hack the EU systems after they leave. Now, that is an extraordinary provision to have to think about putting in so early into the agreement, and that shows the nature of the relationship at times. It's all friendly and diplomatic, but if you have to put in a provision saying you won't hack me, then I'm not sure that we have had the best relationship.
Yeah, trust obviously at a low ebb and continuing that way. Reassuring to hear someone sticking up for the faceless bureaucrats in Brussels as well, that they are looking out for the citizens and that they're not just fixated on straight bananas and the like.
And they never were. They never were. That was an invented story.
They never were, indeed. Let's keep the disinformation to a minimum. Marie, Vincent had mentioned Schrems a couple of minutes ago. Maybe if you could just take that and just elaborate on what impact we think that could have on the adequacy decision and on cross-border transfers to and from the UK then.
Yeah, of course. I suppose Schrems 2 had a monumental effect generally on data protection, in particular, obviously, to, transfers to third countries. Because as I mentioned previously, there's a general prohibition on transfers unless you fall within one of the Chapter 5 exemptions I mentioned. So either you get an adequacy ruling, which in reality is possibly unlikely by the 1st of January for Brexit, or you put in place standard contractual clauses, binding corporate rules, or let's say industries introduce codes of conduct and certification. And I know from a data center perspective, this is probably one of the key areas that as an industry they should focus on, because of all the industries, data security is a fundamental cornerstone for these businesses. And I think it's probably one of the elements that could be helpful and alleviate a lot of the administrative burdens imposed on the by Schrems 2 on these organizations. In addition to that, Schrems, Article 49 provides for certain limited derogations. In reality, they're very limited in practice. They're there and they need to be mentioned, but they're not very useful in reality. And so from that perspective, when you take a step back and you look at Brexit and the effect of Brexit, if there is not an adequacy decision, then we're looking at standard contractual clauses or binding corporate rules as a means to legitimise the transfer of personal data from the EU to the UK, because post-Brexit, the UK will be a third country, as Vincent mentioned. So from that perspective, it's like sending data to the US. So the Schrems 2 decision is hugely impactful in any transfers to third countries going forward. So as I mentioned at the outset, we as lawyers were we were anticipating the European Data Protection Board's recommendations. So they were issued last week. To say, I think there's shock across the board in relation to some of their recommendations, particularly from a technical perspective, is a bit of an understatement. But I think generally they're hugely welcome in terms of they've put in place a 6-step process for organizations to assess their transfers. And these 6 steps will be relevant for organizations that currently transfer data to the UK. So maybe just to touch on those 6 points very quickly, because I'm conscious that we could talk about it all day and assess each step ultimately in granular detail. But I think just so companies actually at a practical level know what steps they need to take. So the first is ultimately to identify and map transfers. This we have been saying from day one after the Schrems decision. But in addition to that, it's inherent in what companies have been required to do since the introduction of GDPR. You're required to know the who, why, when, where, how to of your data, essentially. So from that perspective, you need to map your transfers, including those transfers to the UK. In addition to that, you need to map your onward transfers. So your processors, so your contractors, essentially, you need to know the onward transfer in addition to that, so that you've got a full picture of what you're assessing. So that's the first step. Then the second step is to identify the legal basis that you're relying on. So you'll see I mentioned, so if you're sending data to a country where there's an adequacy decision, you've ticked that box, they've equivalent protection. So it's essentially equivalent to the EU. All is good. Keep transferring, nothing else to do here, full stop. So from that perspective, you're in a good space, hence the reason an adequacy decision would be hugely beneficial overall. If you're then relying on standard contractual clauses or binding corporate rules, you're into a different scenario. So from that perspective, we're looking at Schrems 2. What did Schrems 2 hold? Well, essentially they held the privacy shield was invalid because of surveillance legislation. So the local destination country to which the data, to where the data was being sent, essentially had local laws that circumvented the protection that was put in place by the EU for data subjects. Then if you look at the standard contractual clauses, well, the Court of Justice held that the standard contractual clauses were valid. It wasn't necessarily a slam dunk. What had to be done there is what data exporters need to do is there's an element of due diligence that has to be done. You need to assess the local laws to determine whether there are essential guarantees, and I'll get on to that in a minute, and that's linked to the updated document provided by the European Data Protection Board. And also, if there are not essential guarantees, you need to put in place supplemental measures to protect data, to essentially bridge that gap we were chatting about earlier. So it's essentially to make sure that you can put in place essentially steps or contractual provisions that protect the data from that perspective. So then let's say you move, once you have done so, and once you've determined, let's say, that the specific legal basis that you're relying on, you move to step 3. And that's where you assess the circumstances of this transfer. So unlike current circumstances, and in reality, there are companies sending data wholesale to various third countries. But essentially what is now imposed on data exporters going forward is you need to bear in mind the principles of the GDPR. You only transfer what is necessary for the purpose. You assess the purpose and determine whether in reality it needs to be transferred. And it's back to this accountability, and it all boils down to the accountability principle imposed by the GDPR. So once you assess those obligations, you assess that you undertake a legal assessment of the destination country. So in this case, it would be the UK. And a part of that assessment, you consider the terms stipulated by the European Data Protection Board as they've set out in their essential guarantee document, which I might add is also in draft and is open for consultation. But for the purposes of this discussion, it actually gives us a good indication of where they're going. Part of that, you need to assess surveillance. Surveillance is front and center as part of this assessment. So in reality, when we look at the UK, we have no doubt that supplemental contractual measures will need to be put in place to ensure that the essential guarantees that can't be met because of the surveillance legislation are adhered to at a contractual level. So that's important to bear in mind. So then, because we're relying on the supplemental measures, we move to step 4, which is essentially then what supplemental measures are appropriate. So this is probably the most controversial element of the guidance issued by the European Data Protection Board. And essentially what they have stated is you have to have technical, contractual, and organizational measures. So the 3 components need to be in place in order to constitute valid supplemental measures. So in reality, what a lot of companies have been doing in practice is they put in place organizational measures and contractual measures. But what this guidance stipulates and highlights is that in reality, the technical measures you put in place are probably the key to the protection of the data, because as the Schrems decision pointed out, the protection afforded by the EU to the personal data being transferred needs to stay with the data as it's been transferred and in situ within that third country. So it can't be in any way obliterated. So from that perspective, that's the purpose of having these technical measures in place. So once you put those in place, then you move to step 5 and step 6, which are essentially GDPR principle-driven steps. Step 5 is you need to assess whether you need to get regulatory approval for the specific transfer. That's where if you have risks you can't mitigate, or essentially if you're looking at ad hoc transfers that are going to be by way of a different contract and the relevant supervisory authority needs to sign off on that document as such, then step 6 is your consistent audit and review mechanism, which once again is probably one of the cornerstones of GDPR as part of the overall principles. GDPR is a living obligation, not one you tick the box and move on. It's one that has to be continually reviewed. So from that perspective, these are the kind of 6 steps that organizations will now need to try and put in place between now and the 1st of January. And then in addition to that, we need to determine whether and figure out whether the draft standard contractual clauses that have been published will be finalized in advance of the 1st of January. In my view, I find it quite difficult to believe that they would, given that it's the 10th of December is the closing date for commentary in relation to that consultation. But unless there is an impetus to get it issued in advance of the 1st, it'll be very difficult for organizations to put in place. And I know they are looking at a transitional period, let's say a sunset period like they did for the GDPR for these new agreements. And I think that will be helpful. One additional, I think, hugely helpful element of these new draft standard contractual clauses is the fact that it's one document. We're currently dealing with 2 documents, controller to controller, controller to processor. The new draft standard contractual clause is one document. It covers all eventualities, processor to sub-processor, processor to controller with it. So it covers the to and from that we fundamentally need. So it is covering all bases. It's updating the terms to take into consideration GDPR. These standard contractual clauses, these new ones, have been talked about since May 2018. So in reality, they are welcome. Timing is interesting, to say the least, but I think they're very welcome. In addition to that, they've taken into consideration Schrems 2 also, and I think that's an important point, because there is a warranty within the document that says there's nothing in the third country legislation that prevents or, let's say, diminishes the rights and fundamental freedoms of a data subject. So that they've taken Schrems 2 into consideration. So I think Schrems 2 has had a massive impact on data protection and data transfers, and ultimately data transfers to the UK post-Brexit.
Okay, fantastic. Really comprehensive. Thank you. Una, maybe just taking that point we made about the kind of universal application, are there things people should be thinking about, sorry, not thinking about, are there things people should be doing, right? Because we need to be doing here rather than thinking, that are effectively no regrets, that will deal with the potential for no adequacy decision or deal with the potential for a deal, which they should just be putting in place regardless?
Yeah, and I think it's much to Marie's point, as in those 6 steps, which I think are, it's a big body of work for companies to undertake. I think this close. So as you say, some sort of kind of period of kind of let's say, no enforcement or sunsetting, where there's kind of an adjustment period for companies is going to be important. But I think that kind of having your ducks in a row, really knowing where your data is going, having those 6 steps perhaps worked through. I mean, the best case scenario is that there's data adequacy and you don't need to worry about this, right? But I think we're all thinking that's probably pretty hopeful at this stage. So from a business perspective, and in order to plan, and I know it's what most of the companies are doing, is actually just going through all their standard contractual clauses, reviewing them all now. Now, this is all happening, by the by. And I suppose this is where it inversely impacts on small to medium-sized enterprises much more significantly than larger companies. For the larger companies, obviously this is an absolute headache as well, but they tend to have the resources and the people that they can throw at this, and they can, bring in the experts like Marie and Vincent, and they can kind of work through all those issues. For some of our smaller members, I absolutely understand there's been some times where they're kind of like, I just want to stick my head in the sand, hope this goes away and not have to deal with it. But to be honest, most of them go, okay, I'm going to have to but it's, it's taking a resource away from a critical part of the business and redirecting it to kind of do this just in case sort of exercise, which again, this all costs business money. And I suppose that's kind of the role we play when we highlight to government that, any of these decisions that aren't taken, or where you add extra regulatory burden onto companies, there's a direct financial impact and there's a direct economic impact. And it's something we've been discussing within this sector recently, like the regulatory burden on the tech sector and the veracity and the pace of regulation at the moment is, even for the largest company, becoming a really, really significant economic factor. So if you take that down for even smaller companies, this is a real, sometimes we ask ourselves, why are there no European unicorns? Why is there no, massive, European tech companies or giants? And there are some, but sometimes it's these factors. This is actually what holds us up. It's the length of time and the amount of negotiations, the lobbying, the regulatory, the back and forth, even things like e-privacy, GDPR, all these things, they all take years. And, and you actually have to be quite close to them to be a subject matter expert. I don't claim to be one myself, but I have to be enough that I can sort of make the case for other companies, which is difficult at times. But I think that's the issue that's kind of coming through here, that, at the end of the day, politicians and governments have jobs to do, and their sort of role is to try and get this to happen. Business, on the other hand, is dealing with the fallout of this. And I suppose what we try and highlight is the less that's done at a European or UK level to get this adequacy and get these issues dealt with, the bigger impact it's having on business. And ultimately, then it does cost countries, because you're diminished returns on the economies. So, it's a vicious cycle, and it's one we'd love to kind of put a halt to, or even just get an understanding that regulatory burden costs. And so obviously companies are kind of doing the practical steps at the moment to prepare for this worst case scenario outcome. But really, I suppose, it would have, leaving this to the 43rd day beforehand or longer, because these things are going to take a significant amount of time, that's just not ideal. And I suppose that's when we're highlighting with other regulations that are coming down the track, the veracity and pace, it has to be measured to allow for a level playing field. And interesting I use that phrase, because it's, again, this is preventing new entrants into the market. If you take, large scale technology companies, they can kind of adapt and, to whatever regulations are coming down the track. For some of the smaller companies or even new entrants into market, some of the regulations put in place actually prevent entry in the first place. And so it kind of, has that adverse and unintended consequences reaction of, preventing competition in a market, which actually is one thing that the European Union is, are very strong about, that they want competition, they want, especially European entrants, but actually some of the regulation and the burden that they're putting on companies prevents that. So it's kind of, it's those unintended consequences and the adverse reaction. I think that's what we try and highlight anyway, that, and it's usually, and very much in the European kind of values of trust and privacy and safety, that any of these regulations are proposed, and companies support that. But I suppose sometimes what you have to do with regulations is look at the long-term impact. And if the long-term impact is that you don't have new entrants, you don't have competition, that has to be looked at then. And then, is there a sliding scale? So that's kind of a long answer to what was probably a succinct question.
Well, no, and it's perfect. I mean, maybe, and it gives me something to follow up on as well, which is that challenge around the regulatory burden. And I'm sometimes accused by my colleagues, or they sometimes hate seeing me coming because I'm just bad news at the moment. It's all doom and gloom. So I do like to try and ask, is there opportunity? So maybe that regulatory one, is there an opportunity in everything that's happening here from an EU perspective and, flowing on to an Irish perspective? Like, is there opportunities here for the technology sector and for data centers to try and come out of this having made some changes or having adapted to it in a positive way? And maybe I'll start with you, and then I can see Marie is nodding as well. So.
Yeah, I mean, I think for anyone who's going to grasp this by the nettle, there will be opportunities. I think, as we've discussed, there's huge kind of burden for companies. So I think if you as a company or you as an industry can kind of get to grips with what's required of you, and it's a bit like COVID, even from the tech sector point of view, we saw very quickly those who moved fastest and those who moved, with the best technology have done the best out of this. And similarly with Brexit, and similarly with any regulatory burdens, those who kind of grasp it, get to grips with it and move quickest, they tend to lead, and everyone else kind of follows in their coattails. So that's kind of the advice out to business, is to, I suppose, be on top of it, or be a kind of, again, don't stick your head in the sand, don't hope it'll go away. I think if you acknowledge this is actually happening to the business and deal with it, then generally you can work through it. And actually we've seen great collaboration between companies as well, which has been really positive to see. So actually that best practice sharing, and actually kind of reaching out to people in other parts of the business and saying, we have this issue, what have you guys done? That has been really positive. That's something we've seen through Technology Ireland, that the members, by actually, when you come together and you kind of collaborate and do that kind of, just how does some other company solve an issue, that's where innovation and kind of real creativity can come from. But I'll hand over to Marie, because I think she has more insights here than I might even have.
No, I think I would just echo what you've said, Una, and it's what we saw in practice. So in advance of the decision for Schrems 2, there was an anticipation that a privacy shield may be held invalid, but also kind of that there was uncertainty around the validity of standard contractual clauses. And we could see some of our clients in the data center sector assess this and go, okay, we need to come up with a solution because we need to be ready to go once this decision is issued. And I think from that perspective, you do get first mover advantage. But I think realistically, and I think it's a credit to the data center sector when it comes to data protection, they're very cognizant of their obligations, but also the obligations imposed on their customers. So from their perspective, and we're seeing it kind of in the sector where you see the creation and the building of data centers in specific locations strategically to address these particular regulatory issues. So if you take some European jurisdictions, for example, there's certain, let's say, national legislations that prevent the extraction or transfer of certain data, be it not necessarily personal data, from that jurisdiction for public security purposes and so on. So within the sector, they're creating locations within those jurisdictions to address those specific issues. And the same is happening from a GDPR perspective. And we could see it even from, let's say, then taking it from the flip side, from customers' perspective. Certain clients were so relieved to see after the decision, after the Schrems 2 decision, that there was an option in terms of location of data, whether it be within, let's say, Ireland or the UK or whatever the case may be. So from that perspective, I think for this industry, there's a huge opportunity as well as a challenge. And I think they are grasping it, and they have been cognizant of it from day one, because we can't, and I know I'm repeating Gary Connolly's phrase when he references you can't have a data center without the data. So, and when you look at personal data, more often than not, it is, let's say, at the forefront of the storage requirements, and from a regulatory perspective. So from that perspective, by taking advantage of, and not necessarily taking advantage, but adhering and putting in place options for your customers, you are going to have competitive advantage. There is absolute no doubt at this point in time.
Yeah. Vincent, any bright spots you can point to?
Well, Simon, I can't say it's a bright spot, but I think it's an important point. All right, definitely. I think what's really useful here is regulatory arbitrage. If you think about, if you're planning to build a data center and somebody's challenging it, and they use, for example, some of the EU environmental rules or otherwise to challenge it, you could see the possibility that, for example, the United Kingdom might decide, okay, let's become Singapore on the Thames, or let's actually, scale back some of these unusual or pervasive or intrusive or whatever phrase that they might use, EU rules, particularly on data, but also on environmental issues as well. And that might look quite an attractive proposition. You might say, well, okay, then let's try and think about building this data center in the UK, because we don't have to worry about this particular worm or this particular snail or this particular issue that there is. But think carefully about that, because what you have then is you've got a different set of rules with the UK and the European Union. Now, you still have the data problem and the movement of the data. You've been able to build something, but can you actually operate it? Because, yes, a data center without data isn't any good, but a data center without data that doesn't or can't move is a chocolate teapot.
Mm-hmm.
So the thing then is you then have a sort of an EU rule, which was once implemented into UK law, scaled back somewhat. And the way these cases are often decided, sorry, apologies, this stuff gets very emotional, apologies. How this stuff often gets decided is there's a preliminary reference off to the court in Luxembourg, the European Court in Luxembourg, just like Schrems. That will no longer be possible from the UK. So you've made a decision to build something in the UK. The regulatory regime and architecture looks good. There is a challenge, but now we're not sure whether that rule is exactly right or not, because it's no longer part of the EU or part of the EU regime. And you might say, oh, well, if there's a case in the United Kingdom, before the Court of Justice in Luxembourg, the United Kingdom will be able to intervene. Well, 2 points. First of all, it's lost its right as a privileged party to always intervene as of right in all EU proceedings. It has had that right, it loses that right once it leaves, so it can't intervene. It is then in the same position as the United States, who wanted to intervene in the Apple proceedings. And you might say, well, look, that was 13 billion. Of course, the United States would be allowed to intervene in that. The European Court of Justice said, thank you, but no thank you. You're not going to add anything, and therefore we're not intervening. So the regulatory arbitrage might look like an advantage to begin with, particularly with the construction. But when you can't get to the operation, it's the difficulty. The other thought, Simon, that was running through my mind, and I know there are some Canadian participants on the call, is just something that's actually really interesting. People have been talking about how the treaty or the agreement, if it's agreed, is all about goods, and then the difficulties services. It's really difficult to actually find that difference. You know, law students are everywhere told, you know, a McDonald's meal is basically a good but not very much of a service. A Michelin star restaurant is service and some goods. Now, it's very difficult when you think about something, let's say, in Northern Ireland, where you might have goods like the hardware is moving, and that could be covered by the protocol, but the service is difficult. And I know, for example, when the Canadian EU agreement, the CETA, the Comprehensive Economic Trade Agreement, was implemented, there was a provision in it which said that European shipping companies could operate a service, let's say from Halifax in Nova Scotia down to Montreal. They could operate a shipping service. And one European shipping company turned up and operated on that. And then Maritime Canada said, why aren't you using Canadian seafarers? And they said, well, we don't have to because we're using the right under the CETA. And I said, no. The right under the CETA was about services, but not people. It was services and not goods. It just said services. You still got to use Canadian people. So if you think about something like, and it's a very tangible example with the data center, you've got your services element, but you've also got your goods element. And the goods might be possible, but the services, and that's where it doesn't quite work out so neatly in that regard. So unfortunately, there is going to be complication, and that's why business have to use the great services of Una and her colleagues to actually influence this and think through not so much how it will go right, but how it will go wrong and prevent that in advance. Because that's one of the lessons of Schrems 1 and Schrems 2. Anticipate and think forward and then work. See around corners.
Yeah.
Sorry, Simon, I hope that helped.
No, that's perfect. Yeah, and you seamlessly, with your mention of Northern Ireland, teed up the first question. So Daniel has asked, and this is for you, Marie, I think, but obviously Vincent or Una, feel free to add. So where any business operates separate entities in Northern Ireland, and presumably read UK for that, unless there's a specific issue under the Northern Ireland Protocol, and in the Republic of Ireland, with data being stored in a communal digital storage based in EU data centres, is there an impact on that, and is there issues potentially around segregating data?
This is a common question, to be honest, that we're getting across the board because there's so many organisations that have, let's say, companies both in NI and in the Republic. So from that perspective, and like that, from a cost benefit analysis perspective, they don't want to have separate locations for their data. It makes no economical sense. So for a lot of these companies, the first steps that we've seen these organizations take, and we'd recommend, is undertake that cost benefit analysis. What would be the cost of segregating the data in reality? And more often than not, the cost outweighs the benefit. So from that perspective, they need to look to the regulatory regimes. So then when you look at, and kind of maybe to get a little technical, it really very much depends on what organizations, who's the controller and who's the processor, or are they both controllers? And from that perspective, I think in reality for all these organizations, it's back to the 6-step process that has been implemented by or recommended by the European Data Protection Board. That falls in line with the step process that we have been recommending clients to do all along. Understand the data flows. So while you may be using a communal digital storage facility in the EU, you need to understand the flow of the data. Is it going, let's say, back to RI, then to NI, and so on? And from that perspective, then assess, let's say, the roles of the relevant entities. Are they controllers or are they processors? Then assess, obviously, then back to the same assessments that you undertake, the legal basis. As I mentioned, adequacy, highly unlikely. So we're back to standard contractual clauses or binding corporate rules. And given you haven't mentioned binding corporate rules, I'm assuming that you don't have them in place. So in reality, it is standard contractual clauses. And I think the benefit that we now have with the new draft contractual clauses that have been provided is they will address these specific relationships that the current documents, the current standard contractual documents don't. So they'll cover the flow to and from. NI to ROI to Europe and so on. Whereas let's say the current documents, as I mentioned, they're controller to controller or controller to processor, but they don't address in reality the common relationships that we tend to see between organizations. So from that perspective, I think you need to take the step back, undertake your 6-step test. But once you're assessing the standard contractual clauses and the requirements set out therein, I think in reality, take kind of the positive news that there are standard contractual clauses coming down the line that are adequate and probably more appropriate for this scenario than the current regime in place.
Okay, perfect. Thank you. As a non-data specialist, it sounded like an honours maths question, and that sounded like an honours answer. So thank you. Maybe if I just go around each of you and just ask for one, or two key actions that you would ask or suggest people take in terms of something practical or tangible. Anyone want to volunteer first?
I'll throw myself under the data bus if that helps. Simon, a few thoughts. First of all, I would look internally in your organization as well. In terms of data movements because of Brexit. For example, in our firm, we have a Belfast office, we have a London office, and we have a Dublin office and office in the States and so on. We have to have agreements in the organization for the movement of data. We wouldn't have had that before within the European Union. So start internally and look at what you need to do yourself. So we now have an agreement, for example, for the movement of data from Dublin to Belfast and Dublin to London. You wouldn't have thought about it, but that's what you have to do. So start internally. Then look externally about what you need to do within the European Union, if there's anything, and within the European Union, I know there's a participant from Spain, that should be fine. Then the question is when you put in the United Kingdom into that, and remember it's a cat flap, we're worried more about data going out than data coming in. We're worried about all data, but that's what we're really worried about. And in that context, look at that sort of external dimension. And then don't curse the dark. Think about what light switches we can turn on. And what can we do? And there are two things in particular I think we should think about. One is influencing both sides, the EU and the UK. And the EU, you could, for example, influence through embassies, through your own governments and so on, about what needs to be addressed now. And even if it's a sticky plaster, that there's just a simple article which says this regime shall apply until the 31st of December 2022 or 2023 or whatever, to give headspace for that to be done. And that could be very useful. And then, just like Switzerland started out in 1972 with a free trade agreement and then has over 100 agreements now on all sorts of specific issues, we could see this sort of specific issue being addressed there. And the second thing is to see what can be done at a national level. So, for example, at the moment, there's the withdrawal of the United Kingdom from the European Union bill going through the Irish Parliament. As we know, there's the Internal Market Bill and other legislation going through the UK Parliament. And insofar as that legislation is compatible with EU law, it could address certain issues. I know we've acted for a number of clients, one in particular, where we got provisions into the 2019 Act to address issues so as to solve that problem for them. So I would say that at the moment it's a case of if we can't raise the Titanic, we lower the Atlantic. So I would say start internally, look externally within the European Union, externally within the EU and the UK, and then see what can be done to get the EU to deal with this problem. It's of nobody's making, only those who voted for Brexit, but it's in the hands of everybody to solve, and then I think see what could be resolved nationally. That would be my few suggestions, Simon, and that's an unusual event. That's free legal advice from a lawyer.
He's putting it up to you, Marie. Do you want to follow with some more free legal advice?
Sure, why not? I think from my perspective, and kind of looking at it specifically from a data protection law perspective, I think realistically, and it's back to Vincent's point, you need to understand your data flows, because you can't come up with a solution if you don't understand where your data is going. And I think from a compliance perspective, you're also exposed if you don't understand where your data is going. And as I mentioned, it's not just sending it to your service provider, it's understanding what they also do with the data. And then a second point, and what we have found has worked extremely well for clients that are putting in place their Brexit plans: talk to your service providers, work together, because in reality what we have seen in practice is they want to work with their customers, they want to come up with solutions, and in reality they're having the same discussions with many organizations. So help them to help you come up with the solution that works, be it segregate the data or put in place the relevant assessments or work with you as part of the assessments, because you have to realize it's not an imposition placed solely on yourself as an organization. Your service provider needs to work with you as part of the assessment. The obligations are imposed on them as much as it is imposed on the exporter of the data. So from that perspective, work together to come up with a solution that works. And also look to the technical measures that can be put in place to protect data. Is it encryption? Is it pseudonymization? And I suppose in reality, one of the I think mountains that cloud providers are going to have to climb at the moment is the European Data Protection Board has recommended that customers retain, let's say, the keys for relevant encryption and pseudonymization going forward. Will that work in practice? In reality, I'm not necessarily sure. I've heard some comments in the last couple of days where people have said that this is the end of cloud computing. I don't think so. I think that's slightly dramatic, to be honest. But I think in reality, if you sit down with your provider or have a virtual discussion via a video call, as we all currently are doing, and have that discussion to come up with a solution between now and January, because in reality, time is short. And once you understand what is happening, you're then better able to put a plan in place to solve it.
Great, perfect, thank you. Una, any thoughts?
Yeah, and I'm definitely, I'm not a legal expert, so I might take a slightly different tact on this. And I suppose what I will say from a lobbying point of view, and somebody who's kind of closely involved from a Brussels perspective, is that long-term eye, right? So there's issues coming down the track, or potentially coming down the track, that will have very serious implications for kind of data center operators, people using data centers, and that's all the conversations around the kind of geopolitical, data localization, data sovereignty, the Gaia X project. There's moves afoot that could severely impact this sector, and I think that's something that we as an industry are very closely keeping an eye on. I know some companies are getting involved with Gaia X more, obviously to kind of keep an eye on what's happening. Some are very much opposed. And I think we have to kind of, I think we're all for protections, and we're all for standing up for Europeans' values of trust and safety. But I think that has to come not at the expense of, we don't want protectionist measures. We don't want to have kind of, Europe cut off from the rest of the world. We need to be as innovative as other jurisdictions. And I think Ireland actually has a really crucial role to play here. And that's something that we're calling on the Irish government, through our engagement with them, is that we have to take a step up here, okay? I think there was certainly a reticence to go maybe out too strongly on the data stuff from an Irish perspective at the start of Brexit or during Brexit, because they were dealing with so many other issues, be it the fisheries and the movement of goods, and that understandably had to take precedence. But I think as we move, and especially once Brexit happens, this is kind of a post-Brexit thing. This could actually be far more significant than Brexit. That Ireland, given that we hold 30% of European data in Ireland, has to take a strong position on how data is treated and how where it has to be located. And I think that's the leadership position, and that's something that we'll certainly be working towards. So I'm probably useless on the day-to-day legal stuff, and my colleagues on this call are far more learned than I am. But I suppose what we're trying to do is really highlight that kind of the long-term vision, and kind of the long-term impact, and making sure that, you know, the companies that we have based here can prosper here, can grow here, and they can work in a global context and not just in a European context. So that's kind of my parting line.
Yeah, no, perfect. Thanks. I think, you know, a lot of really good things for people to think about there. And as Vincent said, don't be focused on the dark, focus on the light. There are things that are really uncertain. There are, you know, really difficult things to deal with, but there are things we know. There are things people can act on, and there are things people should be doing. We don't have any questions, so either our viewers have given up in exasperation at how difficult it all is, or we've answered everything for you. I hope it's the latter, and I suspect it is. If I could ask anyone who was willing to chance it, what is the likelihood of a deal? Will we get there or not? Who was brave enough?
A skeleton deal that kind of puts things on a longer term footing. I think that's what the most we can hope for at this stage.
So fudge.
Yeah.
Yep. Two things, Simon. First of all, could I just echo what Una has been saying, which is absolutely spot on. I think Ireland, you know, for as long as we've been a member of the European Union, we've actually had the UK as a bulwark and a breakwater. The European Commission proposes something, Whitehall and the City of London and UK tech and UK industry, etc., goes into overdrive, and then Ireland to some extent can ride on the coattails of that to actually sort of say, well, actually, if you modify this, this would be useful. We're on our own. And we do have 30% of the data. This is a hugely vital industry. Therefore, we've got to actually support it and help it. And therefore, Ireland has got to be now front and centre. We don't have that sort of bulwark or breakwater. The second thing is, I'm not sure quite when the timing will be. It could be, there could be an extension and a delay, and of course that's always a possibility of a fudge. Will we get a deal sooner or later? We will get a deal. It'll be a bit of a fudge, of course. It'll also be a skinny deal and the first of another one. So it's just that this time of the year we usually bring out the Crown as a box set. And we will now bring out a new series of Brexit agreements that will come out around this time, and we will all binge. I don't get out much. I will binge read them, and every year around this time we will get another installment of The Crown, or Designated Survivor, or whatever your favorite series is, because that actually is going to be it. And as far as Brexit is concerned, it is a case of the Designated Survivor.
Yeah, brilliant. No, thank you. And I'm not lost, or it's not lost on me, that the first episode of The Crown involved a very large explosion, and here we are with a standing at the edge of a potential one. Thank you very much to my panel, Vincent Power, Una Fitzpatrick, and Marie McGinley. Really, really great insights. Hopefully that has been useful to you. I have actually learned a lot as well, listening to some of the really, really complicated issues and how people should be thinking about them. And I will hand back to Hugh.
Well, can I just first of all say thank you? And as the only person with an English accent on this panel discussion, I am humbled and can only apologise for the amount of work that perhaps my country has given everybody else out there.
Thank you as well for the amount of work.
I actually found that fascinating. As a small business myself, who actually only runs into Ireland, and that's where I do all my business, I am totally confused. But that's not from this panel's discussion. I think you've got some amazing insights. And I just want to say thank you very much to all of you. I know Marie's had a few technical issues, and I think she's probably dropped out now. But I'd just like to say thank you to everybody who's taken part. What is amazing is how many people have stayed on for an hour and a half. And I think that's a credit to you and the way that you've addressed the subject, and also the importance of it. So thank you very much. Just want to say thank you and goodbye.
Thanks, you.
Thank you.
Thank you.
Thank you.
Take care. Be safe.
Thanks very much.
Bye. Bye.